everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. Today in this video, I am going to discuss one of the most important concepts relating to the law, that is intellectual property right. In this video, I will try to discuss with all the concepts relating to the intellectual property right, which is essential for all the competitive exams. And this video will certainly help you to solve all the questions concerning the intellectual property rights. If we want to know what is intellectual property right, firstly we need to know what is property. Generally, it is said that a property is a thing which can be seen and which can be touched and which can be owned. But there are certain properties which can't be seen, they can't be touched. But these are the properties in the eye of law. These are generally known as intellectual properties, which is the intellect of human mind, which is the creation of human mind. And these types of property are also provided protection under the law. And such type of property generally known as copyright, trademark, patent, database right, design right. So these are the rights which are associated with the intangible property, which is owned by the person or the company and protected against the use without the consent. That's the right concerning with the owner of intellectual property. These are called intellectual property rights. And these are the rights which aim to protect the intellectual property. That is the creation of human intellect or the human mind by allowing the creator of the trademark, patent or the copyright work to the benefit from their creation. If we talk about the international convention such as UDHR, Universal Declaration of Human Rights, also considers the intellectual property rights under Article 27, by saying that every person has the right to the protection of moral and material interests from any scientific, literary or any production of which he is the author. Thus, we can say that intellectual property is an intangible property that comes into existence through the human intellect or the human mind. It refers to the creation of mind or the product of human intellect, such as inventions, designs, literary work, artistic work. It may be in the form of symbol, names, images, which are generally used in the commercial, the business purposes. Thus, the convention establishing the World Intellectual Property Organization also says that the intellectual property shall include all the rights relating to the literary, artistic and scientific works, performance of performing artistic works, inventions of all kinds, design, energy and scientific discoveries, industrial designs, trademarks, service mark, all the rights reserved from the intellectual activities. These are coming under the intellectual property. And apart from these categories of property, geographical indications, layout designs, integrated circuits, or the undisclosed information are also coming under the category of intellectual property. Thus, these are the rights which is used to refer the bundle of rights conferred by the law. Only creator or the owner of the property, which is the creation of his mind. It seeks to protect the interests of the creation or the creator by rewarding and allowing them to retain the property rights over their creations. Intellectual property rights are the legal rights which are governing the use of intellectual property. Thus, there are the certain reasons for the providing legal protection to such kind of properties. Firstly, to encourage the inventions or the creators to promote the social, economic and scientific and cultural development of the society. To provide the legal protection to the intellectual property. To prevent the third party from enjoying their fruits. And to preventing the other party to enjoy the fruits. That is the creation of their intellect. And to facilitate the fair trading, to promote the creation or the creativity, that is the creation of his mind, and giving the recognition to the efforts of the creator and preventing the infringement of the property rights of the creator, and to encourage the investment of skill, time, finance and the other resources which is beneficial to the society. So these are the certain reasons for which legal protection is provided to such type of properties. Now I will discuss one by one such type of property rights by which legal protection is provided to such type of works. Firstly, that is copyright. First category of right, that is copyright. It is concerned or related with the right of the creator of the author, right of creator or the author of the artistic and literary works. A copyright is also generally known as literary right or the author right. And the copyright gives an author an exclusive right to his creation and prevents the copyright from the unauthorized publishing his work. A copyright protection starts at the moment a work is created and expressed in the tangible form. Thus, the copyright protection is granted to a work which is the original creation. And also the protection extends to all the expressions. And mere the ideas without the tangible expression, a legal protection cannot be granted such type of work where there is no expression, where there is no original creation. Thus the original creation is must to get the protection against the Copyright Act. If we talk about the copyright protection, that can be categorized under the two heads. Firstly, that is economic rights, and second one is moral rights. Talk about the economic right. It is the right of the owner to derive the financial benefits from the use of works by others. For example, right to prohibit or authorize the reproduction of the work in various forms. Right to prohibit unauthorized translation of the work. That is the economic right. Second one is moral right. That is the protection of non-economic interests of the author. For example, to oppose the changes of the work, right to claim authorship, etc. These are the moral rights. If we talk about the work which is protected against the author, if we talk about the work which is protected under the Copyright Act, it includes literary works such as novels, plays, poems, that is the original creation of the author, computer programs and databases, films या musical compositions, artistic work such as photographs, paintings, etc., architecture and advertisements, maps and technical designs. These are all coming under the category of copyrights. But it must be the original creation of the author. In India, the copyright protection extends throughout the lifetime of the author. And after his death, it will be protected for 60 years. If we talk about the law related to the copyright, that is Copyright Act 1957. That is a comprehensive legislation that is dealing with copyright in India. And this is the act which regulates all the aspects concerning the copyright regime in India. That will include registration of the copyright, publication of the copyright, that is assignment and license of the copyright, special right of broadcasting, infringement of the copyright, remedies in case of infringement, establishing the copyright authority and copyright societies, as well as international copyright. Section 51 and 52 of the Copyright Act provides what constitutes the copyright infringement. And this was all about the Copyright Act. Next concept, that is patent. Patent is an exclusive right that is granted for an invention or innovative work. That must be a product or a method or a process which introduces a novel or the new way of dealing with the product or something that offers a new technical solution to a problem. In other words, it is a right of monopoly that is granted to a person who has invented a new product. It may include a new and useful article, improvement of an existing article, or a new process of making an article. A patent is generally granted for inventors having industrial and commercial value. It is the exclusive right to manufacture the new article, that is manufacturing the article, with inventive process for a limited period of time. It is generally provided protection only for 20 years from the date of filing an application. In exchange for disclosure of the invention, A patent owner can sell his patent or grant the license to the others to exploit the same. About the patent criteria for an invention, it must pass certain tests. This means the product that is manufactured must be a new product or new article, or it should have inventive step, or it must be known obvious, or it should be capable of industrial application. It is must. If we talk about the protection that is given to the patent owner, it may include he has the exclusive right to prevent the others from commercially exploiting the prevented invention, to exploit the patented invention. And the third parties are prevented from manufacturing, using, selling, etc. the patented product or the invention without the consent of the owner of the patent. If we talk about the patent law that is dealing with the patent in India, that is Patent Act 1970. This act provides for all the aspects relating to the patent. This act provides for procedure for obtaining a patent right, from filing an application to the grant of patent. It also provides for the right of and obligations of the patentee, terms of the patent, transfer of the patent, surrender and revocation and restoring of the patent, infringement and remedies of the patentee. It also provides protection to the patent owner for a period of 20 years. Afterwards, which invented or invention of the technology goes in the public domain. The Section 3 of the Patent Act provides for a list for the non-patentable objects also. That is where no patent can be granted. And also Section 4 provides for patent of inventions relating to the atomic energy, which are declared as patentable. Earlier, no patent could be granted for the medicines, food items, chemicals, etc. And also only the process of manufacturing medicines, food items and chemicals could be patented. After the Patent Amendment Act 2005, patent can be issued for manufacturing products. If we talk about the patent infringement and remedies, any violation of the right of patentee constitutes the infringement of patent. Section 47 and 107 of the Patent Act provides for an act. Those shall not be considered as infringement of the patent. For example, import of machine or other articles by your own behalf of the government or the manufacturer. Manufacturing or use of the patented process by your own behalf of the government does not constitute the patent infringement. If we talk about the remedies available in case of infringement of the patent, that is injunction, damages on account of the profit, or the delivery or the destruction of the infringement product, and the certificate of the validity. These are the certain remedies which are available under the Patent Act. If we talk about the benefits of the patent registration ensures the complete protection of the patent invention against the unauthorized use for a period of 20 years. Second, patent registration allows enjoy monopoly in the market with regard to our patent or invention during the period of patent protection. And the third one is a patent registration confers exclusive right to exploit the patent on the patentee or his licensee or the assignee. We can license the patent and gain the monopoly for the same. Next concept, that is relating to the trademark or the service mark. That is also coming under the category of intellectual property. Or if we talk about the trademark, that is the visual representation or the symbol which is used to distinguish the goods of one enterprise from its competitors. Thus the trademark may be of single letter. It may be in the form of logo, symbol, design or the numerical, and the three-dimensional figure such as shape, packaging, etc. If we talk about the trademark, the concerning statute, that is Trademark Act 1999. Section 2ZB of the Act defines the trademark as a trademark that is capable of geographical representation, or which can be used to distinguish the goods and services of one person from those of others. Hence, the distributiveness is the hallmark of the trademark. The trademark used in relation to the services such as tourism, banking, etc. are known as service mark. Here the owner has exclusive right to use the registered mark There are certain generally 45 classes of trademark consisting of 34 classes of the trademark for products and 11 classes of the trademark for services. If we talk about the function and purpose of the trademark, it is a symbol that identifies the product or its source. Second, it reflects the goodwill of the business. It assures the consumers about the establishing quality of the product. And it serves as an advertisement of the product. A registered trademark provides legal protection to that brand, and it helps to establish a dedicated consumer base by preventing the others from mitigating the brand. If we talk about the infringement of the trademark, it includes the person is not authorized to use the trademark, and infringing the trademark is similar and identical or the deceptive similar or already existing trademark. In that case, that trademark is said to be infringing the Trademark Act. The infringement of the trademark must be used in the course of trade, that is must for the infringement. And the infringing trademark must be printed usually in advertisement, invoices, bills. Mere oral use of the trademark is not infringement. Using either the whole of the registered trademark or the adopted by one by making a few additions or alterations is also coming under the category of infringement of the trademark. Section 29 of the Trademark Act provides for common forms of the trademark infringement. For example, the advertisement of the registered trademark of another for the promotion of one's trademark amounts to the infringement. And following the remedies are available to trademark owner against the infringement of the trademark, that is the filing of the suit for infringement. Also, the criminal remedies are also available in case of infringement. In that case, application for the registration of the trademark must be filed by the person for claiming the proprietorship of the trademark. A single application may be made for registration of the trademark for different classes of the goods and services. And this application has to be filed in the office of the trademark register within whose territorial limit the principal place of the business is established or situated. This was all about the trademark. And the next one is protection provided for the industrial design. The owner of the registered industrial design also reserves his right to prevent the others from manufacturing or selling or importing the articles. Also protected the copying the same design. If we talk about the protection provided for the industrial design, the owner of the industrial design also reserves his right to protect the others from manufacturing, selling and importing the articles, and also protecting the copying of the same design, which is similar to the protected design. That the product coming under the industrial design protection may include industrial products, handicraft items, household products, jewelry, lighting equipments, electronic devices, textiles, etc. This was all about the industrial design. This was all about the intellectual property rights. If you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.